Hello everyone, this is Frank Bridges. This video is a result of our 2017 annual client meeting where we explained several clauses that are available for people to decide to have in their updates, their client updates this year and next. And so we decided to put together excuse me, this presentation to make it easier for people to review the issue. There's this particular presentation and there's a separate one. This one is for the bounty clause, and the other one is for the Clayton election. There's also a third video about the cookie jar power, but that particular video is unrelated to these two. So the bounty clause and the Clayton election kind of go together. So you should listen to both of these videos, both of these presentations, before deciding what to do about them. So today, or in this presentation, just as a summary, the whole point of these things is to balance the estate taxes with capital gains. Because of the change in the federal estate tax law to the $5 million exemption, which is indexed, and now has risen to $5,490,000 this year. The shift in focus on a lot of planning has gone to income taxation as opposed to estate taxation. And the purpose of these particular clauses is really to put a little bit greater focus on capital gains taxes at the same time as we're dealing with estate tax savings. So they're called the bounty clause and the Clayton clause, and this particular presentation is about the bounty clause. Now I should say that the term bounty clause is a reference to the Quicker Picker-Upper, the bounty paper towels. So, and the purpose of it is to kind of graphically indicate that what we're doing is we're trying to soak up someone's federal exemption. So let's get into it. There are several key concepts that we need to understand in order to get there, to get to what we're talking about. The first is the step up in capital gains basis at death. I'll explain. And then the second is marital deduction property. And the third is what's called portability, which essentially allows the transfer of a deceased spouse's unused federal estate tax exemption, also referred to as DSUE or DSU. In other words, the deceased spouse's coupon, federal estate tax coupon, to the surviving spouse. So here's how it goes. Traditionally, you may remember this kind of a diagram when you did your design. When the first spouse dies, their assets, or their trust, becomes a family trust and a marital trust. If the if the deceased spouse has enough assets to use up their exemption amount that goes to the family trust, then we apply the marital trust, the marital deduction, to the rest. So we end up with, after the death of the first spouse, we'll end up with potentially the surviving spouse's revocable living trust, a marital trust for the surviving spouse, and a family trust for the surviving spouse and potentially other beneficiaries, whether they're children or some other beneficiaries during the life of the surviving spouse. So the first key concept is the basis step up. So you know the capital gains basis gets stepped up when property is included in the value of the decedent's estate at death. So when you die, if you die owning a piece of property that's worth $1 million today and you bought it for $100,000 20 years ago, then, you know, if you were alive and you sold it, you'd have $900,000 worth of gain. That's a lot of tax. But because you're going to get taxed at the time of your death in an estate tax, what the law does is it allows you to get a step up in capital gains basis to the date of death value. So if you sold that $1 million property the day after you died, if your estate sold it, then there would be no capital gains tax when the property is sold. And if, of course, you've arranged your affairs so that there's no estate tax as well, then your family's gotten a major tax benefit, notwithstanding that they've lost you and your role in the family. So the capital gains basis of property included in the decedent's estate is the value at the date of the decedent's death. But property has to be included in a decedent's estate in order to get a step up in basis. So if the property is not included in your estate for some reason, and you'll see why shortly, then the basis is whatever the basis was when you got it. So a typical situation where that would happen would be if you bought the property for $100,000 and instead of dying owning it, you gave it away, your donee receives the same basis that you had when you bought the property. So you transfer the basis. And then if you die, they don't get a step up in basis. They still have that capital gain inherent in the property. So capital gain basis step up occurs on the date of death. And now you remember that the family trust is designed, we're going to use the federal exemption amount to pay the tax on the family trust at the time of your death. So at the time of your death, the value of the assets that are put into the family trust does get stepped up to the date of death value. However, if your surviving spouse lives for a few years, any property in the family, and then dies, any property in the family trust at the time of your surviving spouse's death does not get a step up in basis. All right, so in order for there to be a step up in basis on the second spouse's death, whatever we're talking about to get a step up in has to be included in the second spouse's estate. So just to summarize, here's a diagram. You can see on the right-hand side is the family trust, sometimes referred to as the B trust. And on the left-hand side is the marital trust, that's the A trust. And of course, we have the surviving spouse's revocable living trust. So when the surviving spouse dies, the basis of the property in the A trust steps up to the value on the date of the death of the second spouse. But the property in the B trust gets no step up in basis on the death of the second spouse. Now, the next clause that we need to think about is the unlimited marital deduction. So what that means very simply is property that's included in the estate, that property goes to the spouse, is included in the estate of the surviving spouse, is entitled to an unlimited marital deduction on the death of the first spouse. So properties passing outright to the surviving spouse is subject to the marital deduction at the time of your death, and property passing in trust for the surviving spouse under a certain number of different particular conditions, the least of which it has to have at least all income to the spouse, and the spouse has to be the only beneficiary of that trust. So the unlimited marital deduction, everything that goes to the spouse or in trust for the spouse under certain circumstances properly drafted, is deductible on the death of the first spouse. The third concept that we need to talk about is portability. So the current federal exemption amount per spouse is $5,490,000 for a total of $10,980,000, nearly $11 million. And please note, the federal exemption amount increases with inflation, and people have done calculations and have found that it's really hard for the value of a person's asset through growth to keep up with the rate of inflation that gets applied to the federal estate tax exemption amount. So most estates now are less than the combined federal exemption amount, which means that when the first spouse dies, that the estate of the first spouse might not use up the entire amount of that person's exemption. So if that person has less than $5,490,000, they don't need to use the marital deduction, and there probably won't be any marital trust. And so there might be some unused federal exemption after the death of the first spouse. So we call that DSUE, or DSU for short. And so we are allowed, what portability does is it allows us to transfer the deceased spouse's unused exemption to the surviving spouse. So here's what the bounty clause does. The traditional marital trust, family trust formula, that's the one that we just showed you with the A and B trusts, with the surviving spouses, living trust off to the side. On the first spouse's death, the formula directs all property to the family trust up to the federal exemption amount, and it directs the rest of the property to the marital trust to qualify for the marital deduction. So there would be no tax on the death of the first spouse by using the federal exemption amount and the marital deduction. So here we are again. Here's the diagram. Everything that goes to the family trust, we have a formula that says that whatever we have that would fill up that federal exemption goes into the family trust, and if we have anything over that, it's going to go to the marital trust so that we get the marital deduction, and on the death of the first spouse, there is no estate tax. Now, I should note that in Massachusetts, we do have a marital, a different kind of a system. In Massachusetts, the exemption amount is $1 million, but for the purposes of this discussion, it doesn't really matter what the Massachusetts exemption amount is. That'll all work in terms of the formula and how it works. But right now, we're just going to focus on the family trust and the marital trust and the federal exemption. So, in the boundary clause, the traditional marital trust, family trust formula works. And on the first spouse's death, the formula directs everything to the family trust, and then everything else goes to the marital trust to get the marital deduction. So, but the bounty clause is a special formula that's added in to the family trust. So it's a custom formula, limited general power of appointment. It's language that's added to the family trust, and we call it the bounty clause. And what it says is that on the second death, the death of the second spouse, the clause soaks up the family trust property and the surviving spouse's estate up to the remaining unused exemption amount. In other words, all that property that you think about as not being in the surviving spouse's estate that's included in the family trust can end up being in the surviving spouse's family estate by using the bounty clause. In other words, the bounty clause soaks up the DSUE that the first spouse didn't use when they died. So what that means is that since the assets that would otherwise pass without being included in somebody's estate end up being soaked up into the estate of the second spouse, those assets get a step up in basis on the second spouse's death. So here's what it looks like. When the first spouse dies, we file a Form 706 in order to select the portability option. And that's going to be filed even though there's no federal estate tax return that might be due. So even though your estate is less than the $5 million, we're still going to file a Form 706 in order to elect portability of the unused exemption amount. So what happens then is that on the death of the second spouse, the second spouse has a limited power of appointment, it's called the bounty clause, that includes certain assets in the family trust in the estate of the second spouse to die. So that means that we get a second step up in basis. In other words, an additional step up in basis when the second spouse dies. So what the clause really is a general power of appointment. And you probably remember from your design session that a general power of appointment is an appointment that allows the person to appoint property when they die. It's a testamentary power of appointment to anybody in the world, including their creditors, their estate, or the creditors of their estate. That's a general power of appointment. The bounty clause power of appointment, let's go back up to the diagram, is a limited general power of appointment. And what it says is that the surviving spouse has the power to appoint the property in the family trust of their deceased spouse to the creditors of the surviving spouse. That's right. The surviving spouse has the power to appoint property in the family trust to their creditors. And what that does is it means that the assets over which they have that power get included in their taxable estate. So the surviving spouse ends up having the assets in the family trust that it covers included in their taxable estate. But what surviving spouse is going to exercise that power of appointment in favor of their creditors? No one. So what we do is we allow the surviving spouse's trustee to designate, to determine what assets in the family trust will qualify for this limited power of appointment. It has to be appropriately exercised by the surviving spouse, but I'm sorry, at their death. And so the result is that we end up with a second step up in basis by using that limited general power of appointment. So here's what the design issues are. And this presentation doesn't talk about the Clayton strategy, but essentially what it does is it uses the marital trust to provide a step up in basis in all of the property that belongs to both spouses on the second spouse's death. In other words, nothing goes into the family trust on the first spouse's death. Everything goes into the marital trust on the first spouse's death. So everything then it gets included because of that in the estate of the second spouse to die. But remember that the marital trust can only have one beneficiary, and that's the surviving spouse. So having that kind of a plan may not fit what your goals are. On the other hand, the family trust allows beneficiary flexibility. You can have surviving spouse, you can have children, you can have grandchildren, you can have people who are unrelated, okay? And there's slightly greater personal protections. And if you listen to, there's another presentation that we're recording in connection with this year's annual client meeting called about the Pfannenstiel case, which was discussed. That's a divorce case. And the family trust is a kind of a trust that does actually provide greater personal protections than individual beneficiary trusts. So the family trust is kind of provides greater personal protections even without the Pfannenstiel case because of the fact that there are so many different beneficiaries, or could be more than one beneficiary. And the correct design of what you want to choose between the Clayton election or the bounty clause is going to depend on your family's goals and the type and amount of assets that you own. So those are issues that are really counseling issues. And those are things that we're suggesting that people should have a counseling session in order for them to decide which direction to go in their planning. So if you do not elect to have a counseling session, we're just going to leave things the way they are when you do your updates. But there is one thing to think about. Now that you understand what the bounty clause does, it essentially includes assets in the estate of a person that would not otherwise be included. Think about your beneficiaries trusts. If you have a child or if you have a beneficiary after you die and you create a school bus trust for them during their lifetimes, part of that trust is going to be subject to generation skipping transfer tax, and part of it is going to be exempt from generation skipping transfer tax because you have set it up so that it's not going to be included in the taxable estate of the surviving beneficiary. So some of the assets, actually the first potentially up to $5 million of assets that you leave to your beneficiaries, will not be included in their taxable estates when they die. Which means that when they die after all that time, the assets in their trust are not going to get a step up in basis. And if they don't use up all of their if they have unused federal exemption, and assuming that there's still a federal exemption at the time, wouldn't it be a good idea to let them have a bounty clause in their school bus trust to allow there to be a step up in basis for their beneficiaries? So that's the point that we're trying to suggest, is that you can elect to have a bounty clause in your beneficiaries' trusts, and because you understand how that works, there's really no reason why you can't just check that off. So with this presentation, you'll be able to download the checklist that was passed out at the annual client meeting, and you can check off in the middle section that you'd like to have a bounty clause for your beneficiaries' trusts. If you don't want to do that, just don't check it off and send it to us, and we won't include the bounty clause in your beneficiaries' trust. That's the simple solution. So again, we're suggesting that for choosing between the bounty clause and the Clayton strategy, you should consider having a counseling meeting with us. So feel free to call me and make an appointment. And you can use your checklist to opt in or out of the bounty clause for your beneficiaries. So I thank you very much. If you have any questions, feel free to call us. Remember, the first call service, you can call us at any time. We don't turn the meter on for our step 2 clients. You can just call us and ask us questions about your planning, and we're happy to answer them on the phone. Meter's not on, no billing, unless we agree otherwise on some kind of a project. So feel free to call us with questions, and I want to thank you very much for attending the annual client meeting, and we'll see you this year, and we'll see you next year.